Good evening, everyone, and a very special good evening to the park owners and their lawyers who I know will be watching this thinking, what on earth is he going to say? Well, get comfortable because I've got a lot to say. I think there's a lot of things that park owners are doing wrong, so we're going to go through that this evening. Let me start by saying this. Anyone that listens to me regularly will know I do a radio show on LBC on a Friday evening, 9 p.m. And when I do that show, I have a whole team of people sat in the gallery assisting me to make sure that show goes smooth and all goes as it should. This evening, it's just me. So I'm the presenter, the expert, the lighting man, the sound man, and the IT techie man to make sure it's all fine. So please do bear with me along the way if it feels a little bit clunky. Now, what I'm looking to achieve this evening is three things. First of all, I want to provide you with some useful legal advice and guidance and clarification on some of the thorny questions that you've been asking me and that static caravan owners have been wondering and have been struggling with. I was going to say recently, but actually I know it's been for years and years because many people have been telling me this. So I'm going to deal with those issues for you. I'm also going to be answering your specific questions. So if you've got burning questions, I can already see that we've got 120 comments. Some of those will be questions coming in. If you've got a question, I will try and get to that question as well. And for some of you, it may be the first time that you've had the opportunity of a lawyer answering the question. And that gives a bit of an imbalance between you and the big park owners. And hopefully I'm here to make sure that we balance that out a little bit by giving you the chance to have some legal advice. And the last thing I want to achieve, and this is very important because this is what I think is going to solve what you all believe is a big issue in this sector, and that is to collate some important evidence for the Competition and Markets Authority, the CMA. Now, that evidence is evidence of consumer detriment. So where are you as the static caravan owners and other people that contract with these parks, where are you suffering? Where are you experiencing consumer detriment? Hopefully I'll get some of that out this evening. I'll tell you in a minute how I'm going to do it, but also to highlight where are the breaches, if any, of consumer laws? Are these parks breaching the consumer protection laws that we have in this country? Anyone that listens to me regularly will know I'm always going on about these laws. I'm always saying that we have the best or some of the best consumer protection laws in the world, but they're only as good as the enforcer. So we have to enforce these laws. So the idea here is to get all of you people that are online to answer questions along the way during this live stream so that I can present that to the CMA and show them that this really is a sector that needs to be looked at. Let me start by saying this. I have been looking at this very closely. There's been some great people that have been helping me with this, people that are leading your groups, providing some fantastic information. I'm already convinced that this is a sector that needs to be looked at. So I don't have to be convinced by that. I already know it is. Now I want to do all I can to give you a voice because obviously I do have a media platform and I'm going to use it to the best of my knowledge and the best I can to help you with that. So for the sake of tonight, I'm going to assume that everyone's pitch license agreement is the British Holiday and Home Parks Association, the BHHPA, hard to say that, template. That's the latest template. Now, before you all start screaming and sending me messages, I know that you don't all have that agreement. It's obvious. In fact, I've heard from many people, and it's very clear that there's all sorts of agreements in circulation. But I'm going to assume it's that for this evening because that will give us enough to provide what the legal position is and to spark the CMA into hopefully doing something. Also, I'm not giving out specific advice during this live stream. This is generic. I can't possibly, we've got 1,126 people viewing at the moment. There'll be many others because I know this problem, and I'm going to say this now, this is for the sake of the CMA. I know there's groups out there with 16,000 people in the group. There's others I've seen with 5,000. There are tens of thousands of consumers that this matter that we're dealing with this evening, where it impacts on them. And this is why it's so important. This is not something which only applies to a few people. So don't worry if I'm talking about an agreement that you do not have, it doesn't matter. Most of my advice is still going to apply to you anyway. And I will be providing some advice on different types of agreements in another live stream and on my online blog as well. So again, don't worry about that too much. Now, the ultimate question is this: it's whether the terms within this agreement or any of the other agreements that you may have are fair to consumers, or are they unfair, or as us lawyers say, do they amount to an unfair contractual term? Do any of the terms amount to an unfair contractual terms within the consumer protection laws, primarily the Consumer Rights Act? And I'll be going over that in a while. Now, I've had many questions. I've seen there's many issues that people are experiencing. They've got lots of questions about those issues. You'll appreciate I can't deal with all of those this evening, but I am going to deal with all of those. But I'm going to deal with them this evening and in a second live stream that I will do on Sunday. So I need to break it up. Now, for the sake of this evening, I'm going to deal with two principal areas. The first one is pitch fees, and I'm going to break that into two questions. Question one: do these include services such as cutting grass, or are those services free? Are they not part of the pitch agreement? This has been the million-dollar question during the lockdown. Why? Well, because lots of the park owners, you know this, you've been telling me, lots of the park owners are saying, well, sorry, we've been closed. We've had to by law. That's true, by the way. We all know that. And even though we've been closed, we're not giving you any type of refund or reduction because all those other services are not part of the pitch fee. So what are they saying? Well, they're saying that all you're doing is paying for the bit of land, effectively, where your caravan is situated. That's what they're saying. So I'll be answering the question, is that true? Now, to answer that question is not me giving you a one-liner saying yes or no. That doesn't help you. I'm going to give you some explanation. I'm going to go through why, or a journey, a consumer journey, to reach the conclusion that I'm going to reach, because that's what you need to know. The second question under pitch fees is it fair that these parks year on year get to increase the pitch fee, and they just get to pluck it out of the air and decide what the new pitch fee is going to be? Now, I'll pause there, because if I know there will be park owners watching this, and they're all going to be saying, well, we don't pluck it out of the air. That's just nonsense. Well, I'm not making this up, because many people have contacted me, I would say in the thousands, and many have made that statement, and that's why I'm making it. So don't shoot the messenger. Your customers are telling me that that's how they feel. So the question tonight, the legal question for me is, can you do that? Is it an unfair contract term for a consumer, in this case, a static caravan owner, to be party to a contract where they have no say on the increase in the pitch fee? They are there playing a lottery, wondering year on year if they are going to be able to afford the new pitch fee, and what it's going to mean for them. I'll be answering that question for you as well. The last area I'm going to look at this evening is termination provisions, and one specific issue, which is many people have been telling me that when they've complained about pitch fees or anything else to the park owner's response has not been, well, let's have a look at that complaint. Let's deal with that complaint, as you would expect a normal provider of a service to do. Many park owners, and I'll pause again, I'm not saying all, so don't get excited, Mr. Park owners. I'm not necessarily accusing you of this, but I'm saying many. And again, I can clarify that, I can justify that statement, because many people are telling me this. So many are saying, well, there's now been a breakdown in relationship, and because of that breakdown, we're turfing you out. That's a breach of contract. So my question this evening, what I'll be answering for you is that a breach of contract? Can they really do that? Can they deploy these bully boy tactics and scare you into not complaining, not taking legal advice? And the other thing as well, I say there are now 1,433 people viewing this live stream. I have had probably more than 15,000 people throughout the week saying, oh, we want to review your live stream, but we're scared to. Why are we scared? We're worried what the park owner will do. Is that right? I'll be coming back to that very shortly. Now, once I've gone through all of this, and the format will be, I'll explain the legal journey and the legal position as I see it. I'll then go through the CMA evidence that we need to collate. That will be me asking you questions and you simply on the messaging part of the system saying yes or no if it applies to you. Then that will give me great evidence to submit to the CMA. And then once I've done all of that, at the very end, I'm going to go through your questions. Now, bearing in mind that on Sunday, I'm going to come back to the other issues. Let's just look at what those issues are, just so you all know I'm going to deal with everything. And if I'm not dealing with everything, you'll let me know. I'm going to look at tied services on Sunday. So, can the park really and lawfully make you use their contractor, their preferred contractor, for decking services to build your decking? Can they make you use their gas supplier? Can they do all of these things? Can they tie you into tied services? Or should you have the ability to shop around? We therefore live in an age now of comparison sites, of shopping around, of switching things. When you're at home, you can switch your energy provider, your phone provider, and all sorts of things. Should you be able to do that at your caravan park? We'll be looking at that on Sunday. And also, there's many provisions that I would say are draconian provisions in relation to when you sell your caravan. Should you be tied to going through the park owner? Should you be losing? Some people are telling me 15%. Should that happen? Again, I'll be looking at that on Sunday. So when I come to the end of the live stream this evening, if any of you ask me those questions, I might skip over them because it's probably a better place for me to answer those once I've gone through the legal position with you. It doesn't mean I'll forget them. I'll save them all. I'll transport them over to Sunday's live stream and I'll answer them. And again, I'm going to make sure I answer as many of these questions as possible. And I will be, after we've done these 2 live streams, making a detailed legal video on all these points because I'm trying to give to you all of the legal power and knowledge that you need to take the next steps. The next steps, which we'll go over on Sunday. So don't anyone fire off issuing court proceedings after this evening. Ultimately, I'm going to be telling you not to do that anyway, but don't be trigger happy. Wait till I finish everything I'm going to do. So let's start off with pitch fees. And you remember the first question I said is, are you entitled to a reduction during the period when the park has closed? Now, of course, we've got a great example of this in recent times. We have a pandemic. We have the lockdowns. And therefore, during these lockdowns, I think we're now on the 3rd lockdown. Sometimes hard to keep up with this. Is the park entitled to say, sorry, we're closed? Or does that amount to a breach of contract? Now, as I go through this, I'm going to be referring to some law. Can't get away from that. And I'm a lawyer, and that's what I do. And the law is relevant. So when I do that, I'm going to try and put it on the screen for you. I'm pointing over here because I've got a great big screen that I need to keep looking at, which shows me my control panel. And I'll be referring to the license agreement as well, just so you know what's relevant along the way. Now, my view, my generic view to start with, is that in most circumstances, the answer to the question I've posed is going to be yes, i.e., yes, you are going to be entitled to a reduction in these fees. That is the pitch fees in relation to the elements that are services that they can't perform. Grass cutting, probably one of them. I say probably because some park owners may say, we're still cutting the grass. I know that many of you have told me during other lockdowns, lockdown 1 and 2 especially, that wasn't happening. Collecting rubbish, they don't need to do that. You're not there. Security and so on. So if any of these things are not being provided, my initial reaction is they're going to have to give you a reduction. Let's have a look at why. So here's what I'm hearing from park owners, not necessarily direct, but via you. Here's what they're saying. They're saying there are 3 primary reasons why they do not have to give you the reduction. Reason number 1 is that the primary purpose of the license agreement is to give you permission to keep your holiday home on the park and permit you to use it during the permitted period of occupation set by the agreement. I know you've all heard that. I'm just reciting it. That's the main reason I've heard. The second reason I've heard is that as part of the right to occupy the pitch, the park provides amenities to the pitch, such as utilities and access to the facilities as well. But the park is not obliged to provide those facilities to you, particularly when the park's closed. So what do I mean by that? Or I should say, what do they mean by that? Well, what they mean by that is they're saying, again, I said it at the start, you're paying for that bit of grass, or it may be a hard standing, to where your caravan's going to be situated. In addition to that, and for free, you're going to get these other services. but we don't have to give them to you. We're not contracting to give them to you, and you're not paying for them. They just come as a freebie as part of the caravan. That's pretty much what they're saying. And again, some park owners watching this now or later are going to say, we're not saying that. Well, I think you are actually, because that's what I'm hearing and I've seen it in writing. The third reason, and this is the most frustrating reason, and I know you're all going to have questions about this, is that park owners say the pitch fee is not broken down into component parts, such that it would not be a case of simply reducing the pitch fee to take account of periods where we can't provide grass cutting and other services, because we don't do it like that. It's one fee just for that bit of land. And of course, we all know that's nonsense, but those are the reasons why they say, actually, we're not going to give you a reduction. So in short, what they're saying is you pay for the actual pitch, but everything else is free. And not importantly, this part, it's not a contractual obligation to provide the services. So let's now look at the legal position. The Consumer Rights Act, which is the main law that covers anything consumer. And anyone who listens to me will know it's the main law that I'm always bashing on about. It's that law that's on the screen there. That law says that terms, that is terms of a contract between you as a consumer and any trader, in this case, the park owner, must be clear. And the key terms, anything financial is a key term in my mind, must be made prominent. And I'm always saying this, but it's true. Consumers must always get what it says on the tin. So if the tin in this case is a contract, says you're going to get A, B, and C, then you must get A, B, and C. Now, the Consumer Rights Act greatly empowers consumers. It is a pro-consumer piece of legislation. That means the trader is always on the back foot initially, and you as the consumer, and me as the consumer in other occasions, are always on the front foot. So that's the starting point, which is we're in a good position. Now let's dig a little bit deeper, because Section 50 of the Consumer Rights Act, and I'm going to put it on the screen, basically says that where representations are made to a consumer pre-contract, i.e. before you've signed the dotted line, the consumer is allowed to rely on those pre-contract representations. And they're able to say that that becomes a term of the contract. So why am I mentioning this? Why is that relevant? Well, because many of you have been telling me that when you went to the park where you were going to buy your pitch, or in some cases buy the caravan and the pitch, I think that's the most common scenario, you asked about pitch fees. Well, of course you did, because the pitch fee would have been one of the most important aspects of the whole purchase. Because let's face it, the caravan is an initial upfront fee. You may have paid for it on finance, and it may therefore cost you along the way. But the pitch fee is another recurring fee that you will have to pay for the life of your agreement there. So it's going to really matter to you what that fee is. Now, many of you have been telling me that when you spoke to the salesperson said to you, well, the pitch fee is this, but it includes all these wonderful things, grass cutting, security, and any other weird and wonderful things they may have included in the pitch fee. So what you have to ask yourself is this: when you agree to enter into your pitch agreement, your license agreement, and you heard the pitch fee amount, did you think, well, that sounds reasonable, bearing in mind what's included, grass cutting, security, rubbish collection, all the other things? Or did you not care about what was included? Did you just think, well, that's the pitch fee, that's all it is? So let me rephrase that. If I said to you the pitch fee is £1,000 for the bit of grass there, would you be more enticed by that? Or would you be more enticed if I said the pitch fee is £1,000 for the bit of grass or the hard standing? And what you also get with that is it also includes grass cutting, security, rubbish clearance, and all the other things. Now, it doesn't really matter what you think the answer to that question is. What really matters is what would the reasonable consumer say? How would the reasonable consumer answer that question? And my view, my very strong view, and being someone who's been a consumer lawyer for more than 20 years, who's been in the media for a long time now as well, who speaks to consumers all the time, my view is that the average consumer, the reasonable consumer, would say, actually, I would have been enticed buy all these additional services as part of the pitch fee. Therefore, I would have considered that because the salesperson told me about all of these, that they were included in the contract. And if I'm right about this, it basically means that section 50 that's on your screen now, or an explanation of what that says, engages, and it means it becomes a term of the contract. And that means that now you can say to the park owner, that pitch fee, sorry, does include all the additional services. It's not just the bit of grass or the hard standing. That's what that means. Now, ordinarily, a breach of contract, and let's take an assumption for a moment that this becomes a breach of contract because there is a term that says you're entitled to all these services. Ordinarily, a breach of contract means that you can get some compensation or rip the contract up. And of course, if they've not provided all of these services, that would technically be a breach of contract. It's not the case here, though. And to be fair, people have not been saying to me that they want to claim breach of contract. They've been saying to me they want some recognition that the services haven't been provided. I make the point because I have seen some people issue court proceedings saying there's been a breach of contract. There hasn't. And the reason there hasn't is because we've got something in law called force majeure. Force majeure clauses in contracts basically say that if a contract can't be performed because of an event such as a pandemic, then there's no breach of contract. You can't sue for compensation, but you may be able to get a refund. And that's why we don't necessarily go down the breach of contract route so much. Now I'm going to bring up another piece of law. And this is the same act, the Consumer Rights Act, but it's section 56. Again, it's up there on your screen. And what section 56 says is that it gives you the right to a price reduction if you are not receiving everything you should receive. Now, here we know that's what the case is. In my case and in your case, we're saying that you're not receiving the services. So we would be saying to the park owners, well, the services are part of the pitch fee and therefore are part of the agreement for the reasons I just said. I've not received them, so I want a price reduction in accordance with section 56 of the Consumer Rights Act. And that would be the law that you would be stating in that situation. And that's why I'm mentioning section 56. Don't worry if I'm going too fast with this. I am going to do a very detailed and slow video on it next week. So don't worry too much. So if I pause at this stage and come back to my initial belief, my belief is that in most cases, a court would find that parks should provide a reduction for the services that cannot be performed during park closures. Now, I've heard some park owners say or cite that there have been court cases where they've won on this point. That may well be true, but I've not seen them. In fact, the court cases that I've seen, the static caravan owner, the consumer, didn't sue, didn't try and make a claim as I've just explained it. They were making a claim that actually the park shouldn't have closed or closed contrary to the license agreement. Well, that was a really easy argument for the park owners to defend. That was an easy argument for them to put forward, and they were obviously going to win that argument. So I wouldn't be worried when park owners are batting around this whole we've won court cases. By the way, it's normal. It's normal for companies to do that to consumers. Why? Well, we call it scaremongering. And that's all it is, because my view is very firm here. I believe that in many cases, you would be successful. But I should say this as a bit of a disclaimer. You have to look at these on a case by case basis because you've all got different agreements. Remember what I said at the start? I'm concentrating on the most recent agreements that I've seen. Some of them may say different things. It may be some cases where you were clearly told at the start before you got your pen out and signed the dotted line, or in the current age, signed it electronically on a computer, and were clearly told that services are not included. And maybe there's no other evidence to support your position. Of course, in that case, I wouldn't be arguing it. You would lose. But in many of the cases I've seen, and I think probably I'll be so bold as to say most of the cases, that's not going to be the position, and you'll be in the prime position to be successful with any claim. Now, of course, That tells you what the law is. We then need to look at what evidence should you be looking at in this situation. So if you had this argument, what would be the evidence that would point towards you as the consumer, me as the consumer lawyer in this case, telling you this being right? Well, here's some of the things I've seen. So what we are told before the agreement was signed. I've said this already. Many people are telling me, well, I was told these services were a part of the pitch fee. Not they were free, they were part of the pitch fee. I was entitled to them. That word entitled is very important. Why? Because it's the same as an obligation, really. And the reason it's important is the park owners will lead you to believe that they've got no obligation to provide these services. They're free, they're a sideshow. Many people telling me that that's just not what the salesperson said. Also, I've seen many websites, this is park owners' websites, where they clearly state that the additional services are part of the pitch fee. Not that they're free, not that there's no obligation to provide them, that they are part and parcel of that pitch fee. That's what you, as the consumer, as the static caravan owner, are paying for. That's good evidence to suggest that they have to provide those services. I've also seen YouTube videos produced, made by park owners. Go on YouTube after this live stream. In fact, you're on YouTube already. Search YouTube for park owners. You will find on many occasions that there are videos where park owners explain pitch fees. Of course they do, because pitch fees, as we've already established and as you already know, are important. They know that potential customers want to know all about them. They know that this is a sales pitch, and the videos I've seen are clear. Included in the pitch fees are electricity, grass cutting, security, and all the other wonderful things that they include. I've seen many arguments where the park owner denies all of this. But to be honest, there's so much evidence in many of the cases I've seen, which is contrary to those arguments that the park owners are putting forward, that it cannot be true or cannot be legally correct, that they are simply not included. So again, my firm view is in many cases, and I keep stressing this, not all, but many, if not maybe most cases, you are going to be entitled to that price reduction. Now let's bring in another useful law, because law is always a good thing to use. I'm still on the Consumer Rights Act because that is that wonderful piece of law that greatly empowers you and me as consumers. Now the next one is called Section 68. And what this says is that all contractual terms must be transparent. What does that mean? It means they must be clear. You must understand them. They can't be written in Chinese. They can't be in a font size that you need a magnifying glass to read. They must be transparent. They must be clear. That's what this Section 68 says. Well, we now start to see a picture forming where pitch fees and what they include is anything but transparent. I keep saying it to you. I'm looking at websites. I'm looking at YouTube videos. I'm looking at sometimes what the agreements say. And to me, as a lawyer of 20 odd years, I'm thinking pitch fees include services. But the park owners are saying, no, they don't. They're citing all sorts of reasons why they don't. They're citing clauses in contracts and license agreements. They're citing other things that points towards their argument being right. What does this all mean? Very clear. It means it's not clear. It means it's not transparent. Because if it was transparent, clearly say to you, nope, it's very clear, doesn't include that. You're not entitled. But I can't say that. And that leads me to believe that the reasonable consumer also couldn't say that and would believe that they're not transparent. So what does this mean in law? So what does the law say when terms are not transparent? Well, again, the law is pro-consumer. And we then go to another part of the Consumer Rights Act, which assists consumers in this quest. And that's Section 69, the very next section. And that provides that where there is a conflict, the next word's more important, or confusion, the position which is most favorable to the consumer will prevail. So here we have confusion. You and me believe that services are all included in pitch fees. Rubbish collection, security, grass cutting. I keep saying it, but these are the services that I keep being told are the relevant ones. We believe that they're included. The park owners, on the other hand, believe they're not. They'll swear blind they're not. They'll tell you that there's no way they are. They're free. They don't have any obligation to provide you with those services. What does that mean? Well, us believing that they're included and them believing they're not equals confusion. So clearly here there is confusion. Now, what is the most favorable position to you as the consumer? Well, it's very clear. It means that the services are included. So if it goes to court, you or me or whoever would be telling the judge, I believe it's this, they believe it's that, it's confusion. So the court is invited to assume that the services, the grass cutting, etc., are all part of the pitch fee. And therefore, the legal and contractual consequence of that would be that all of those services would have to be performed. There would be a legal obligation on the park owner to perform those services. And I believe that's what a court would find in the right circumstances with a consumer with the right agreement and all the elements that I've described. I believe that's what a court would find. And this would mean that you would be entitled to a partial refund if any of these services were not performed during the lockdown period. Now, I should say this at this stage. We cannot make the generic assumption or statement that all of these services that I keep making reference to have not been provided during lockdown. I know some of them have. I've seen evidence from park owners that some of them have, but certainly not all of them have. I've also, by way of converse, heard park owners say, well, we're still cutting the grass. And then I've seen pictures of grass that's like up here, or we're still emptying rubbish. And for some reason, there's bins that have got black bags flowing out of them. Where that rubbish came from, I do not know, because apparently no one's there. But I've seen this evidence as well. And where I'm pushing with this is all about evidence as well. If you believe strongly that you have a claim here, it's all about what evidence you can collate, what contract you have, and what all your individual circumstances are. But generically speaking, I think these claims would be very, very strong. Now, I've also seen contracts, as in the license agreements and documentation, that clearly confirms that pitch fees are arrived at, that is the amount of the pitch fee, after considering operational costs. What does that mean? Well, in most cases, operational costs would mean what it costs the park owner to basically operate and run the park. Now, grass cutting is part of that, security is part of that, taking away rubbish is part of that. These are all operational costs. So this is more evidence that these pitch fees do include these additional services. Otherwise, why would you have to take operational costs into account when setting what the fee is? And I'm going to come back to that a little bit more in a while. But if you look at clause 8.4.4 of the current standard pitch license agreement, it deals with pitch fees, and it clearly makes this point, because it says changes in our operating costs include those brought about by changes in the law or regulatory changes and by taxation. And again, these operating costs are all about what it costs to run the park. And you, as the caravan owners, are, of course, picking up the tab for that. Now, look, when I put all of this together, it's very clear, ladies and gentlemen, very clear that I can rest my case. I believe that these park owners should, in most cases, be refunding partially some of these fees. By the way, I have convinced some park owners to do that when I've been not acting for people individually, because as you know, I don't do that anymore. But when I've been sort of pushing them, they have agreed to do that in many, many cases. Now, on my website, the consumerlawyer.blog, there it is on the screen, there are some detailed advice blogs about this subject. There's also a template letter on there as well. If you are minded to do something now about this, read that first. I cannot stress enough, please don't go issue legal proceedings at the moment. I'm going to tell you why later, but I don't want people to jump the gun, waste their money, lose. Let's try and deal with this as a collective in a way that I think is a better way of doing it. I also want to give you a word of warning at this point. As I've said, I've seen some people issuing legal proceedings in the court against these park owners, and those proceedings have been on the basis that the park owner shouldn't have closed the park during lockdown, i.e., there's a license agreement that says you're entitled to go to the caravan. Because you couldn't during lockdown, they're in breach. And for that reason, they've got to give you a refund. So the remedy you were looking for, the people that have done that, was correct, i.e., a partial refund for services you not had. But the legal journey you went on to get there, i.e., the breach that you were claiming, which in all the cases I've seen has been you breached the contract because you closed, was wrong. That's not the breach. That's not what you should be aiming at. The other word of warning is that I've heard many people talking about frustration of contract. Now, frustration of contract is something that it's been around for many years. It's a contract law term that lawyers use. It's a term that I was using very often in the early days of the pandemic when holiday companies were canceling holidays and then not giving consumers their money back. And they were basically saying they weren't entitled to that money back. And I'm not going to go deep into frustration of contract and its meaning, but it had a place in those arguments. Now, there are people out there that are not lawyers who have been writing advices for people saying, oh, it's frustration of contract, you should claim that. In some cases, lawyers have been saying it. This is not the time to claim it. And my reason for that is very, very clear. When you claim frustration of contract, it means the contract cannot be performed in law. That is the case here because of the pandemic. They can't provide these services for you. They can't allow you to go to the caravan. But there are two issues with this. Number one, they can't do that because another law overrides their contract, i.e., the lockdown laws. Therefore, there's not a good legal claim there. But also, even if there was a good legal claim, frustration of contract, if successful, means you rip that contract up, you assume you never had it. So, how many of you really would like to pick up your caravan and move it off the current park, try and find somewhere else, pay all those extortionate charges for disconnection services and all those things? How many of you want to do that? I think the answer might be zero. And if it's not zero, it's going to be very close to it. What you're looking for is some recognition that you're paying for something that you're not getting. So frustration of contract is not the way to go. And I can't stress that enough, and I'm sorry to labor it, but many people keep falling foul of this and making a mistake, and it's costing them money. That's not where we go. Right, I've been rabbiting quite a bit. I'm going to stop for a moment because this is the Competition and Markets Authority, the CMA time. This is the part where I'd like to provide some evidence for them. So bearing in mind all of what I've just been saying, what I would like to ask you now is a bit of audience participation. And I'm going to ask you a couple of questions. And the first question I'm going to ask you is, who has asked for a partial refund from the park owner and has been told no? All you need to do is, if that's you, just put yes. If it's not you, don't do anything. And I'll leave you a couple of minutes while I drink some water, not vodka, to give me those answers. By the way, they're really important, these answers, because it really is good evidence for the CMA. And any of you that saw that I was doing this recently with teletext holidays will know how successful this was in our quest to get the CMA to investigate, which they're now doing. So many people saying yes, no surprise. I'm also hearing yes, but no reply. That's also a very good answer because that also shows consumer detriment. If a trader ignores a consumer, especially where there is a long-term contract in place, as here, that is not good. That does show consumer detriment. It shows, or it suggests, that they may be dodging their obligations. And this is a sort of evidence that is good to show the CMA. Someone says that someone said that they were told that the park had business interruption insurance and they'll get back to them after they've had a response to that. If anyone else has had that, please do tell me. It seems like people have got that. Two things I'm going to say about that. First of all, some of you may have seen the press in recent weeks. There has been a high court case going through about this business interruption insurance. On this case, the villain is not the park, it's the insurers. Anyone who listens to me regularly will know I'm always giving the insurance companies a hard time. Why? Well, because often they are saying no to claims. But the good news here is it seems that the high court ruling is going to pave the way for the likes of these park companies to get a payout for the insurance. But let me say this, that shouldn't be stopping them refunding you. Nothing in the law, nothing in the Consumer Rights Act says that in circumstances where you're entitled to a price reduction, that you have to wait for an insurance claim to be seen through by the trader. Nothing says that at all. If any park owner disagrees with me, please do tell me the section number. It must be on the page I've not read, the page that fell off my version of the Consumer Rights Act. Or in other words, it's just not there. So some people are saying also they need advice. Well, I think they do need advice actually, because I think they've been getting the wrong decision. They've been telling you the wrong things in many cases. So I'm not sure why they needed advice. Some people are telling me that they've not given refunds, but they've increased. They may have given them some kind of a deal for the 2021 fees. Actually, there have been some brands, some park owners that have done that. I was involved in one group that did convince them to do that. And in some cases, that ended up being good. Some of you may have been involved in that as well. And in some cases, it's just not been a good deal. So, of course, you can accept that type of deal. Um, it's perfectly valid for them to offer that. But ultimately, you as a consumer should not be out of pocket. So the deal they give you for 21 or 22 has to properly recompense you for what you've already lost with the reduction in the services. Okay. So as I expected, lots of you given answers to that. You're all obviously having the same issue. Message for the CMA very clear. Lots of consumer detriment. Potentially, if you agree with me that this is a breach of consumer laws in many cases, then there are huge examples, lots of examples here of breaches of consumer laws by different park owners as well. So I'm going to move on to the keep telling me the answers while I carry on, but I'm going to move on to the second question under pitch fees. This is a question that many people have actually been asking me, which is it fair that park owners can increase pitch fees randomly each year? And what I mean by randomly is basically they can make it up. They can say, this year your pitch fee is going to X, next year it's going to Y. Should they be able to do that? Well, in all cases that I've seen, it's been clear that the consumer knew that the park reserved this right before they signed the contract. So they knew that this agreement they had signed meant that the park owner had the right to increase the pitch fee at the end. And before you all sigh sort of a disappointment, that doesn't mean it's right. I'm just saying you knew about it. If anyone didn't know about it, please tell me. But in most, well, not no, in every case I've seen, I think people did. Um, the only times when maybe they didn't is if it was concealed, and that would be a whole nother legal argument that I won't go into now. But on the whole, generically speaking, I think most people did know. So the question therefore comes, is the term fair? You knew about it, or most knew about it, but was it a fair term for you as a consumer to sign up to? Well, we need to go back to the law for this, because the Consumer Rights Act also deals with when terms are fair or unfair. And we need to go to what is called Schedule 2 of the law. I'm going to put it on the screen for you as well. So this here is Schedule 2. Now, Schedule 2 of the Consumer Rights Act contains what we call a grey list. And this grey list is a list of terms, template terms, that the law says may be unfair. And that's why we call it a grey list. Now, term 14 on that list is pretty much as I put on the screen there. It's a term which allows traders to increase the price, in this case, the price of a pitch fee under a contract, in this case, the pitch fee license agreement, um, basically without having to go back to the consumer. So here, the consumer doesn't have any rights to argue it. And I know some people may say, well, we sort of do. I'll come back to that. This is the whole 33% thing. Come back to that in a moment. But this is a term where basically you sign up and you're agreeing that forevermore under this contract, I've got this term where the fees can be increased and I've got no idea how much they're going to be. So the starting point is the law, the Consumer Rights Act, under Schedule 2 on your screen there, provides that that may be an unfair term. Now, the law goes on to say that it's more likely to be an unfair term if there is no method in the contract or explained to you before the contract as to how the increase will be done. So if they increase it by 10%, why are they increasing it by 10%? Is there a formula, a method for this? The law says, well, if there's not a method, then it increases the chances of it being unfair. And that, I'm going to conclude shortly, I think is the case here. And the courts have found time and time again that simply telling consumers that there will be a price increase isn't enough. There must be a method given to the consumer so that they enter the contract with their eyes wide open as to how that increase will be calculated and therefore what it possibly may well be. Because otherwise, what stops a park owner who thinks, let me give an example, a scenario here. Let's say a park owner is approached by a housing company and the housing company says, we're going to give you £10 million for the land or £20 million for the land if you sell it to us now. And the park owner thinks, well, I've got all these license agreements. What do they do to get you off the land? Well, what they could do is when the next pitch fee increase comes around, they could say, oh, that £1,000 a year is now £20,000 a year. You'd all leave. Technically, they could do it. This is why the law says, hold on a minute. We need to look at this. Consumers need to go into this with their eyes open with some kind of an idea as to what the increase will be, some kind of a method, some kind of a formula. So the exercise I'm going to look at now is if you look at the latest license agreement, because what we've got to do is come away from the law a minute and look at what does this agreement actually say? Does it provide you with a method? So if we start off by looking at clause 8.2. Now, whilst I'm mentioning clause 8.2, there may be something similar in your license agreement if you don't have the recent one. There probably will be. But again, I'm just concentrating on the current agreement for now. I think most of what I'm going to say will apply to your scenario, but it may just apply in a different way. It may be that you've got different clauses, but I think it's going to be pretty much the same result. So clause 8.2 of the current agreement says, we will give you a written explanation of reasons for any increase which is proposed. So what's the problem with that? Well, remember what I've just told you, what the courts like to see and what the law is recognizing is that a method should be told to the consumer pre-contract. Well, this is after the event. This is saying we're going to increase your price and then we'll tell you all about it. So that's too late in my mind. Also, what does this written explanation look like? Well, many people have told me it doesn't look like much. It's been pretty much a one-liner saying your pitch fee is going to increase to X, full stop. That's what many people are telling me they are told. You would expect when you read that clause that they're going to give you a detailed explanation as to what it involves and why they've increased it. But many people tell me that just doesn't happen. So that's the starting point. Now let's look a bit closer. So if we come off this 8.2, I'm on the same license agreement now, and I'm going to move to clause 8.4. 8.4 says, when we review the pitch fee, we may take into account the following factors. Now, I'm not putting them all on here, but these factors set out what they may include in a price increase. Some of them are very sensible, increases in rates, inflation. You have to understand all of those things. They start sounding like a formula. Therefore, you start to think, well, maybe they're okay with this. But then I get to clause 8.4.4. And that says changes in our operating costs, including those brought about by changes in the law or regulatory change and by taxation. Now, the reason why this troubles me is that most parks are saying that operational costs are not factored into pitch fees. We just spoke about that on question one a great deal. We know they're saying that. But of course, they really are. And this clause proves it. This is a good proof that these services, which fall under operational costs, do form part of that whole pitch fee and how they arrive at the figure. And most parks, and this is where the real big problem, and this is why I say this troubles me, is if any of you have ever asked a park, your park owner, please can you give me a breakdown of the operational costs? Please can you tell me how much you're spending on grass cutting, security, and all those other things? I bet that most of you would tell me if I asked you that question, that the response you got was either, sorry, it's commercially sensitive information, or sorry, it's just confidential. But ultimately, we're not telling you the answer. That's what they all say. So let's pause for a moment. Let's come back to what I was saying a moment ago, formula methods. Have they now given you the method of how they are going to calculate this new fee, this new annual pitch fee, or whatever the period is, if they won't give you what's probably one of the most important elements of the formula, i.e. the operational costs? Answer, in my view, no. Of course they haven't, because that's something they should have told you. So if you have no idea what those costs are in the first place, how they calculate them, what they're going to go up by, then you've got no type of formula. Now, park owners may say, well, yes, you do, because you know that the things we're going to factor in are A, B, and C, including operational costs. But without knowing how they arrive at those operational costs, I would argue you've probably got half a formula. And what good is that to you? In my view, it's not. So this secret squirrel thing that they do and how they act, I think goes against this whole argument of you not having a transparent view of what this would look like. So I then move on, and I'm still on the license agreement. I now go to clause 8.3. Now, here it says the proposed change in the pitch fee will become payable with effect from the review date unless not less than 33% of the owners of caravans affected by the proposed change in the pitch fee write to us objecting to us. Now, of course, I know this did used to be, I think, 51% or 50 something percent. So we've got a good change in the right direction, reducing the percentage. Does it matter? In my view, no. Why? I'll tell you why. Because many of you are telling me that despite the fact you've got this in here, which should be a good security measure for you to put the brakes on for scenarios like I explained a moment ago, the builder comes along and offers £20 million for the land. The park owner says, oh, I want to get out of here and get this 20 million. Mr. Static Caravan owner, I'm now charging you £20,000 per annum. You would think this is your protection. This is the clause that would stop them to be able to do that. But that's not what you're telling me. Because what you're telling me is that if you have ever tried to put the brakes on and be part of the 33%, you're met with a brick wall. And many people have told me that what they have tried to do is they've tried to club together. Of course, it's the sensible thing to do. It's what you would expect people to do in order to try and reach the 33% together. And then you've collectively gone to the park owner and said, look at all of us. We represent 33% or nearly 33%, and we're not happy. So what does a park owner then do? Well, they don't say, well, Christ, because most of my customers are not happy, I better do something here. No, that's not what you're telling me, what they've been saying. They've been saying, sorry, we don't deal with people as a collective like this. You've got to come to us individually, one by one, and then we'll talk to you. We're not dealing with you as a group. Why? Well, because there's strength in numbers. That's why we're doing this live stream, not just for me to tell you the law. It's because there's strength in numbers. to show the CMA and show the parks that you've all clubbed together is a powerful tool to have. But what you've got here is that your park owners, or many of them, as you're telling me, basically say, well, actually, we're not letting you do that. There's not strength in numbers because we're stopping you from doing any of that. So this presents a big problem. This feels unfair. And when something feels unfair in a contract, often it is. This feels very unfair. In fact, everything about this clause, this whole concept of you having to sit there and wait to see where the wheel of fortune has gone with your new pitch fee, cannot, in my view, ever be fair in situations where you simply do not have the right to know what the method is or to complain about it and effectively to appeal. So let's now look at the next stage of this, because the law looks at lots of things when it decides, or when a court decides if a term is unfair. It looks at all the things that I've just mentioned. It will take all of those things into account. But the other thing it will do is it will say, okay, if you have a consumer that enters into a contract, a long-term contract, as these are, and is tied by an increase in price, if the consumer doesn't like the price, can that consumer get out of the contract? Can he or she terminate the agreement? Well, I come back to the main license agreement here, the one that I've seen recently, and it does not give you the ultimate right to terminate just because of a fee increase. So you don't have that right. Now, at this point, park owners will say, yeah, but it doesn't really matter, because in most cases, the static caravan owners can get out with 1 month's notice. So they're not really prejudiced by this. They can get out anyway. Okay, that could be a good argument, but here's why I think it's not. Because I've asked many of you, what does it mean to terminate one of these agreements? Can you literally just put a letter in, 4 weeks later, move off the site, job done, and easily move somewhere else? And of course, the answer to that question, unless any of you are going to tell me otherwise, the answer to that question appears to be no. The reason it's no is because then the park owner comes in with its great big sting in the tail, like a scorpion, and stings you for disconnection charges and all sorts of other things. And it may well be that you can't move that caravan off the site for contractual reasons, or because it's just not in the right condition to move it. Or if you can, of course, there's a huge expense in doing that. And then you've got to find somewhere else to relocate. So unless the park owner agrees and says to you, I know I've increased the price, I know you don't like it, but don't worry, because what I'm going to do is I'm going to allow you out of the contract now, and all the costs that are associated with you terminating, I'm going to pay all of those for you. And you're all laughing at this point, because, of course, no one's going to say that. None of these park owners are going to offer to do any of that. But unless they do any of those things, my firm view is that, again, this just breaches all the rules in the book. And therefore, I cannot see any reason why this clause in these agreements can be deemed as being fair under the Consumer Rights Act. Now, I should pause at that stage and say, there are obviously people who have agreements that do not come under the Consumer Rights Act. That act came into being in October 2015. That's when it came into force. So if you were prior to that act, you wouldn't be under that law. And the law isn't as good prior to that in terms of what is and what isn't an unfair term. We had a separate act of law. I'm not going to go into it because I don't want to confuse people, which dealt with it. But that act also dealt with unfair contractual terms, and also the Office of Fair Trading, as it was then called, it's now no longer around, but did lots of studies, including in caravan parks, and spoke about unfair terms. And in my mind, clearly was pointing towards this type of term not being fair. So my overall view here is that these terms, where you are bashed into a contract where you have to accept the new pitch fee amount year on year, or whatever the period is, where you don't really know how they arrive at the new fee, where some of the elements of what's made up in the pitch fee are secret, MI5 like, and where you have no real right to appeal, to challenge, and where to terminate is going to cost you a huge amount of money. With all of those elements, my overall view is that these terms are actually unfair. And that's what I'm going to put to the CMA, the Competition and Markets Authority. I'm going to wrap this up in a legal opinion to them saying, in most cases, that's the situation, and therefore you need to intervene and look at that. There's already papers in there complaining to the CMA, which are good. This is just going to really top and tail that to make sure that they're aware of the legal position. So I was talking about CMA. I'm going to pause there again for a moment because this is that CMA moment where audience participation is needed. You haven't got to sing me a song, but what you have got to do is answer me some questions. And question number one is, have you ever disputed the pitch fee and effectively been told, tough luck? So answers are literally yes. If you haven't, just be silent. No surprise, lots of yeses coming in. I thought that'd be the case because that's what you've all been telling me. But again, let's get it all here. Okay, so the next question is, have you been refused a breakdown of the pitch fee? And what I mean by that is when when you basically have said, I don't like the new pitch fee amount, and you've then gone and said, how is it made up? Can you give me a breakdown? Have they said, no, we're not giving it to you? Someone on the chat said it's not looking good, is it? Just I hope you didn't mean it's not looking good for you as the caravan owners, because my view is this is not looking good for the park owners. Is my very strong view here, and I think if we put this together properly, if we put it together in a good way with lots of evidence, this and other stuff we're going to have to get, I think this is going to be looked at, this market, this industry, and there's going to be some big changes in my view, and there needs to be. Although naturally, I can't promise it, but I think it'll happen. Okay, so the next question is, do you understand how your park owner arrives at its pitch fee every year? So you've heard me saying that um, that lots of the park owners, and evidence I've heard, won't tell you anything, won't tell you how they arrive at things. You've heard me saying that the law really wants to see a method. So what I'm asking you now is, do you know? Do you know how your park owner arrives at the pitch fee? And if you don't, just say no. And I can see a lot of no's. Okay, no surprise. No, not a clue. And keep those answers coming. But I guess what comes next from that is, do you feel bullied by your park owner? Do you feel that being kept in the dark, being told no for things that affect your pocket, that affect your wallet, affect your money? Do you feel like you're being bullied by the park owner? While I'm giving you some time to answer that question, someone said, "Does all of this apply to all license agreements?" Um, the answer to that question is, of course, no, because every license agreement could be slightly different. I know that the most of them use the standard template From time to time, that template changes, and therefore there'll be different terms. Some of you may have a real historical agreement, which may not say some of the things that I'm saying, or may say things that are worse. So I'm giving you a generic overview, but I think you'll find that what I'm saying does apply to most of your scenarios. And I think the generic theme of this, which is, are consumers being treated fairly by park owners? Not in all respects, because of course there'll be many things where they are treated fairly, but on the defined questions I'm asking, I think you'll probably find, regardless of whatever agreement you've got, the answer is probably going to be no in many cases. Um, as you probably would have heard and would have picked up from me talking about consumer laws, consumer laws are all about making sure that the consumer fully understands what they're getting into. That's why I say it does what it says on the tin. It's an important expression because it's so true. So if you go along to a park and the park owner or the salesman says, right, you're going to have, this is what you're going to pay every year. Just so you know, this only includes that bit of land there. It doesn't include any services. We're going to every year increase the price. This is how we're going to arrive at it. This is what we're going to do. If you don't like it, you've got a chance to appeal by doing X, Y, and Z. In that type of scenario, probably they're doing what they should do. And by the way, there will be parks that are doing that. What I'm saying doesn't apply to all park owners. I don't want to tarnish everyone with the same brush. But unfortunately, there are some big park owners that affect many of you that, in my view, are doing this wrong. And I keep stressing this. It does matter what's happened on a case by case basis with your case, not just, it's not all the same. We can find some common ground, and quite a lot of it, where you've all been treated in the same manner, but you've very much got to look at what you've been told at the start, representations, and all the other areas like that. So that brings us to the end of that question. And we've got lots of good evidence there that I will obviously submit. Hopefully, that gives you a good legal overview of why I think this automatic increase of a pitch fee, or right to an increase in a pitch fee, is just unfair under consumer laws. Again, what I'm going to do, because there's actually a lot more to this, but if I go in too much detail, I could be here all night, and your popcorn may have run out by then. I am going to do some separate videos on this. Videos, because it's really good to be able to show things visually, where I'm going to pull together some examples that I've seen. Some examples I've mentioned tonight, but not been able to show you. It's easier for me to show it in a video, and I will put those out next week. So don't worry too much if I've gone too fast. I'll put it out there. But the main thing is to say, I think there's going to be some changes in this sector. So the last bit I'm going to go on to is termination. And if you remember, the question here that I was going to answer is, when any of you go to your park owner and you raise a complaint, or you say you're going to send a legal letter, whether that be using a template I've given you from my websites or something you've picked up somewhere else, or if you've gone to a lawyer, in these circumstances, can the park owner effectively rip up your license agreement and tell you to get on your bike? Now, many of you say, yes, they can. Many of you tell me that the park owners have used these words, break down in relationship. Sounds like a marriage has broken down. We're not married to the park owner. And in fact, it doesn't matter if there's a breakdown in relationship, really. But let's have a look at this in detail, because what we've got to get to is, can the park owner really do that? Now, this is a really important question. And I know how important this question is because many people haven't joined this live stream this evening out of fear, almost mafioso-like, out of fear that they will be turfed out of the park. And it's not an exaggeration, and you know it's not exaggeration because you're all involved in this. So many people fall into this position. And of course, that can't be right, but that must breach every rule in the consumer protection law book. It must do, because we can't have a situation where consumers feel bullied, feel like they can't assert their rights. That's a basic right that everybody in this country has, that apparently, and I'm saying apparently because I only know what I'm being told, apparently some park owners are thinking that they can take away from you. So Let's put this into context. The following points are important. First of all, the agreement, and again, I'm talking about the agreement I've been talking about all night, the license agreement, provides an example of basically what a relationship breakdown is. So I'm going to first of all go to clause 11. I'll put it on the screen there. And this shows when a park owner may terminate your agreement when they're legally allowed to do that. And what this says is they can terminate if there is a breakdown of relationship. Doesn't mean I'm agreeing with them, by the way, because what you then need to look at is, well, what does the agreement think a breakdown of relationship is? Well, we're lucky here because this agreement gives an example. And the example that it gives refers to violence or damage to property. And that's a million miles away from you complaining, sending a legal letter, or getting a lawyer involved. That's not violence. That's not damaging or damage to property. Of course, if you get a law book and go and whack it over the park owner's head, that's different. There is a breakdown of relationship there. And I should say, I don't recommend that any of you do that. But if you do what you should do, and you do it properly, and you simply send a letter, or you get on the phone, or you complain, that's not, according to their own agreement, a breakdown of relationship. Now, clause 5 of the agreement is headed behavior standards. Now, you would think that if a breakdown in relationship is a breach of contract, that here it would talk about what the behavior would have to be for that breakdown of relationship to occur. That's what you would think. But that's not the case, because nowhere in this clause, I'm not going to put the whole thing on the screen, it's too long, but nowhere in this clause does it say that complaining or taking legal advice contravenes what's acceptable, what's deemed acceptable. And the reason I'm saying what's deemed acceptable is because this behavior standards clause is all about what behavior do we as the park owner believe is acceptable for you as the static caravan owner, as the consumer. It doesn't say, well, it's not acceptable to complain. I mean, what trader in their right mind would tell you is unacceptable behavior to complain? Can you imagine walking into Tesco's or any of the other supermarkets or any of the shops on the high street and saying to them, these goods I bought are faulty, and them saying, that's unacceptable behavior. There's a breakdown in relationship here. Go away. Don't come in our shop ever again. No, of course not. They'd never say that. If they did, they'd be all over every news channel in the world. They'd be the subject of almost lots of videos on my YouTube channel. And of course, none of you would ever go back to that shop again. So of course, the unacceptable behavior is on them, telling you that complaining amounts to a breakdown in a relationship. Now, perhaps the most compelling argument here is seen when we go to clause 17.5 of this license agreement, and it's coming up now, because that clause says, it talks about alternative dispute resolution, ADR. And what it's basically saying is, look, if we all fall out, we can go to ADR. And we can go to ADR where an adjudicator or an arbitrator will look at both sides of the story and decide who's right or wrong. But then it goes on to say, but if you prefer to go to court, this license agreement does not in any way prevent you from doing so. Now, of course it doesn't, and it couldn't, by the way. But the fact they call this out and the fact that they say specifically that you're not breaching the agreement by going to court surely means that you're also not breaching the agreement by complaining, by taking legal advice, by sending a letter of complaint. Of course not. So the conclusion to this question, and it's a really short answer really, because it's so ridiculous this. The conclusion is, if a park owner tells you that they will terminate the agreement if you complain, if you join a live stream, if you take advice from a lawyer, if you send them a letter before action, anything like this, if they tell you that, they are wrong. That's not a reason, a legal reason to terminate that agreement. Now, whilst I'm only talking about the current license agreement, the template, I'm pretty sure the same will apply to all of the agreements. Nowhere will there be a lawful clause that allows them to terminate your agreement just because you've complained. That's wrong. Now, I know, and I'm horrified by this actually, but I know that there have been many cases where this has happened. I've seen it, um, where people have told me, either it happened to them or someone else that they know, that they were turfed out because they complained, lost everything over it, cost them a fortune to move the caravan or just to leave it there. That was wrong. And my message to anyone who's in that situation or has been in that situation is you have a claim, in my opinion. Um, you should ought to get a lawyer to look at the claim, because you should never just trot off the court and willy-nilly and make a claim. But my view is you have the grounds, the bones of a very good claim for compensation, because these park owners, and I say this very loud and clear to the park owners now, you have no right to do that. That's a breach of consumer laws. But more importantly, you've got no right to do that under any of the license agreements I've seen. And I challenge any park owner who believes otherwise to give me the legal basis as to why they think they do have that right. And I go on then to give a clear message to the Competition and Markets Authority, the CMA. This is another good example, probably the most horrific example of consumer detriment and clear breaches of consumer laws. If you don't do something about the sector, this will continue and people will continue to be detrimented when that should never happen, especially in a country that is so pro consumer as this one. They are riding roughshod all over our very good consumer protection laws, which of course are worthless unless we do something about them. That's all I'm going to say about that area. Again, I will be doing a video on that particular point as well, because I feel very strongly about that point, because I've seen too many cases where people have said, I got turfed out and I shouldn't have done. No, you shouldn't. And I'm going to give you some more legal basis for that. What I'm going to do now, before I do so, I'm just going to remind you that on Sunday, I am going to pick up the other areas. They're important areas. Lots of people have been asking me about the issue when you sell a caravan. So I will be dealing with that in quite a bit of detail because it's important. Lots of people ask me about as well about hikes in, for example, electricity. I saw someone a minute ago just say 25% hike. Is that allowed? I'll deal with all those points as well. It'll be an overkill if we do it too much tonight. What I'm now going to try and do, and this is where I'm going to remind you that it's just me sat here, no producer, no one else helping me. I'm going to try and just run through some of your questions on here, bearing in mind that a lot of them are answers to my questions. So it might take a minute to find some of them. Afterwards, I'm going to print all these out and make sure that I at one stage answer all of them where there is a question. And again, I'm going to try and dodge the ones that are to do with subject matters that I'm going to deal with on Sunday. So let me have a quick look to see if see some of your questions here. One moment. So somebody asks, where do we find template letters? Quick answer to that is if you go to my website, and I'll put it on the screen for you now, that website there, the consumerlawyer.blog or .co.uk, have a search through it. You'll see that there are Park Dean articles, advice blogs, sorry. And within some of those there are template letters. There's also template letters in various other holiday and travel advice I've given on there, which may be useful. But what I will also try and do is produce some more for this particular matter. There is, by the way, a template letter, what you should use if you want to know how a pitch fee is broken down. So do use that as well. I hope that answers that question. Oh, I'll quickly answer this. Is the customer always right? Well, apparently it's good customer service for the customer to always be right. But let me answer that question in this way. Remember what I said. The consumer laws are pro-consumer. And that means the law is recognizing that the consumer should always be right or nearly always be right. Of course, Daniel, the answer to the question is no. The consumer or the customer is not always right. But I happen to think here, more often than not, you will be. That's my answer to that. Amanda says, I have had 3 letters from Darwin Escapes stating that if I don't do what they are demanding in the letters, then I'm in breach of my contract. Well, it's quite hard to answer that question because, of course, I don't know what they're asking you. But if they are asking you to do something which you're obliged to do in the contract, then yes, they will be right. If they're asking you to do something which is not in the contract, then no, they're going outside of their own contractual powers and they're not entitled to do that. So, my advice to you, Amanda, is to basically look closely at your contract and try and marry up what they're asking you with the terms of the contract. If the two don't tally up, and if they're asking you something which you're not obliged to do, then you can go back and say, I'm not obliged to do it. If you're not sure, go back and say, can you show me or can you refer me to the clause in the contract that gives you the right to ask me to do this, and see what they say? And I think that's probably the best thing to do with that. Um, So, does the information you have given this evening about license agreement apply to leases too? Yes, if they're to do with a park. So, if you have a lease, which means some kind of a longer arrangement, then yes, it will. But my disclaimer with that is, of course, I've not seen any of these leases. If anybody wants to send me one, I'll have a look at it. So, therefore, I can't conclusively tell you that it'll be the same position because I've just not seen them. But if you've got the same generic problems that I've been explaining this evening, then I'm fairly certain that a lot of the answers I've given you will apply to this as well. Just looking through. Forgive me, I'm just wading through lots of questions. Okay, this is an interesting one. So I was pulled up on a comment I made on a caravan owner's Facebook page. I guess what you mean by that is the park owner basically said, we're not happy you did that. Take it down. There's a fine line with this because, on the one hand, park owners shouldn't be restricting you from complaining and airing your complaints with others. But on the other, you can cross the line. You can say things that become defamatory, which would be actionable in law. So if you said something that wasn't true, then of course you could be sued for that. And you can incite, which means some of the things you say are causing others to follow you and cause them business interruption. Now, if it's warranted, that's okay. But if it's not, you can fall on the side on the wayside to being an issue. I would say the safest thing to do if you want to air your thoughts in an open forum is to do it on more of a closed Facebook page, like what a lot of you do, and certainly don't go and do it on the caravan owners page. You're better off arguing, putting your complaint to them direct in writing. Many people say complaining on social media and an open forum gets traders to move, gets them to do something. I'm not someone that subscribes to that. I never have done. Yes, it's true that sometimes that gets action, but often it also gets inaction where the trader will close down on you and not respond, or will some kind of counter sue you. Now, of course, when you have a complaint about anything, you want to make sure that it's a one-way complaint. You never want to give them ammunition to come back at you. Here, you've got park owners who have got a very easy way of resolving a complaint they don't like. What is that way? Terminate the agreement. So if you do something which gives them any cause to do that, and maybe I mentioned earlier the behavior standards clause, it may well be this would fall within that. So I wouldn't risk it. I would do this the proper way through the proper channels rather than doing that type of activity. That's just my thoughts on it. Um, I'm going to bring this up for a reason because Mark here says some owners in the association are scared of retribution. Of course, they are, no doubt about it. I've mentioned this a few times. I brought it up to highlight it again because they shouldn't be scared. If you have a legitimate complaint, if you feel that your consumer rights have been breached, you have the right in law to complain about it, to put your foot forward to say, something's not right here. I should get this, but I'm not getting it. That's the situation here. So, really, you shouldn't be scared. The message I want to put out loud and clear to park owners and via the CMA is this cannot continue. You cannot take this course of action with people. People, I shouldn't be getting questions like that, or should I say statements like that. It's just wrong. Um, Yeah, and this just highlights the issue again. Alison says, no idea what is included in the pitch fee, not broken down in the invoice. That's probably an answer to one of my questions, but I'm just highlighting it again because I think so many people are in that situation, and it is really, really ridiculous. I'm going to go to the end of the chat page there. If anyone wants to ask me a specific question, because it's very hard to pull them out from this, again, I will deal with them after. Ask it now, and I will quickly try and deal with it and sweep up all the others afterwards. Someone says there's always a mole in relation to closed Facebooks. Yes. You're right. That is the case. I've heard that many times before. And if any of you think that there's not park owners or their representatives watching this, then think again, because there will be. I know when I've done in the past, but we should be public about this in one way, because of course, you are trying to assert your rights and you're entitled to do so, in my opinion. Um, This is an interesting question. Is it true that annual license is just that, and when ended, no duty to renew? It really depends on the license itself. If you think about it, when you enter into a pitch license agreement, often you would have bought a caravan from the same site, and you'll want to have the security that you can house it on that site for a certain period of time. In those circumstances, no, it would not be right that you have to renew the license every year. That would just be wrong. But again, I pause with some hesitation. It depends on your actual agreement. If that's the situation and you weren't aware of that, in my view, that wouldn't be binding, because if you signed up, parted with your money to buy a caravan and to pay the initial pitch fee and everything else, believing you had what landlord and tenant lawyers call security of tenure for a certain period of time, then that's what you should have got. And if, Steve, your question is going towards that, saying, well, you didn't realize, then I think you'll be in a good place. But again, it depends on what you were told, what you believed, and what you believe when you signed the dotted line and got yourself into that agreement. If that, it's not an issue I've heard much of actually, but if it is a big issue, then please more people tell me. Even when the live stream finishes shortly, you can still go on and, I believe, and add stuff, and I'll look at it and I'll deal with all of these questions, including that specific one as well. Um, James says, why do the CMA fob complaints off to trading standards? And why do trading standards not deal with these issues? What do we have to do to make these authorities act? I thought I'd just answer that question because a lot of people ask that question. A lot of people ask me that on LBC on a Friday night as well. And the answer to that question is trading standards are there to deal with local issues. So the CMA is obviously a central body. So what they would rather do, the CMA, is in the first instance, is pass your local issue to the local trading standards to where your park is, where the park owner is located, and where the park, where your caravan is located, I should say. And what they should then do is look to see if there's any breaches of consumer laws. Now, they are inundated with work. They are under resourced. They do a good job, but they're under resourced. And often they'll only act if they're seeing mass consumer detriment. So if there was a park with, say, 1,000 park caravan owners on the park, and all of the 1,000 owners went to trading standards and lodged a complaint, they would do something. They definitely would. But if only one or two do it, they won't do anything, because they've got to look at the mass problems. The Competition and Markets Authority is there to look at more mass problems. So if they feel there is consumer detriment in the market and something's going wrong, mass breaches of consumer law, they will look at it as a matter of policy centrally. That's what we're trying to do here. Now, as you can imagine, I'm not being a CMA spokesperson here or salesperson, but they will get many, many complaints thrown their way. And during the pandemic, they've had that. They have actually, on the whole, been a very effective organization and have done good work. And we should only commend them for that. But they get loads of complaints coming through. They have to wade through those to decide which ones warrant their time and attention on a budget which is not endless. And that's why sometimes it can feel this way. I'm sticking up for them because there's been a few occasions in the last 12 months where, I've pushed them to act, as have other people as well on the same matters, and they have acted when they should have done. I believe here we've got a situation where this needs to be carefully explained to them in legal terms. They've already got a great document that's been put in by Carol Keeble. She did a brilliant job with that. They've got that document. And as I've mentioned to her, we just need to top and tail it with the legals of it, as I've been explaining this evening. And I think there's a very good chance they will do something. Although, again, I can't promise it, but I believe there's a good chance that they will. Um, do I have to pay the park site fees if I walk away and abandon my caravan on their site? Well, the answer to that question is almost certainly going to be yes. And the reason for that is that you'll be in breach of contract. So you'll have your license agreement where you've got to pay certain the pitch fees and anything else you've got to do for the period of time you're there. And I imagine that what would happen if you did that is that they would say to you, we're now going to charge you storage fees, or maybe even disposal fees of the caravan. Again, I'm giving you a generic answer because I've not seen, Henry, your particular license agreement, but I know many do say things like that. So I wouldn't recommend that as a course of action. The better course of action, if you feel that strongly that you need to get out, is to simply try and sell your caravan. And by the way, I know that comes with many issues. We're going to deal with them on Sunday, but I can't stress enough that's not the route to take. That probably will end up in a disaster. So I'm going to do one more question. And again, I will sweep all the others up later for you. Um, oh, so I don't think that's necessarily a question. Um, someone has, I've just missed it because it's gone, but I'm gonna make this my last answer. Someone asks about if you've got if a new park owner comes along and you've got no contract with the new park owner. Um, the default position with that would be that you would still be under the original agreement. So just because the park owner changes hands, it doesn't mean that they can automatically push you onto their new agreement unless your current agreement provides that they have the right to do that. And again, it probably wouldn't, because if the new park owner's terms and conditions are more onerous than those that you've currently got, this is the same situation as the increase in the fees. When you entered the agreement, you did so on the terms and conditions that you currently have in your current agreement. They can't force you to now accept new terms and conditions that you knew nothing about at the time, unless you agree and they give you something more for it. Actually, it's a good question because many people I know are in this situation. Parks have changed hands quite a bit over the years, and I've heard this question quite a bit. But I wouldn't be concerned about that because I don't think that they can force you. Not, I don't think I should say they cannot force you into those new terms until you come to the end of your contractual term. So it shouldn't really matter. So I hope that's been helpful. Um, to sum up, I am going to put all of that in a couple of separate videos in a bit more detail. I'll look through all the questions that you've all been asking me to make sure that I've dealt with them all. We'll do another one on Sunday with the other key questions that you've been asking me this evening, because some of them are obviously very, very important. Sale of caravans, hikes in electricity fees, tide services with decking and all sorts of things. These are all the things that you're experiencing on a day-to-day basis that are all very, very important. I am on LBC on Friday, 9 p.m. If anyone wants to listen, or if you've got any questions you want to ask me during that show, we take phone calls during that show on the number on the screen there, 0345 6060 973. You probably know I'm on Twitter at Dean Dunham, where you can also contact me as well. I'm going to do all I can to help with this situation. I make no promises. You'll understand I can't. I can't represent people individually because I'm too busy doing media work and campaigning like this. But what I can do is collate all of your evidence together, look at this from a high level overview, and give my considered legal opinion from my sort of 20 years experience of doing this on what the situation is. And as I say, if you can't join me on LBC on Friday, I hope you can. I'll be back on Sunday, 8 p.m., doing another live stream for all of those matters. I will put some notices out about that, and we'll deal with all the other issues and look at the next steps. Now, before I go, please do not issue legal proceedings between now and Sunday, because I don't think that's going to be the way to go at this stage. If anyone's to issue legal proceedings, I want to make sure you're armed with all the right information, all the right templates, you're saying the right things, and you're suing the right party. I say that because often people sue the wrong party and they get booted out of court. Hope everyone stays safe. I'll hopefully hear from you Friday or Sunday. And I believe we will get somewhere with this issue. Might take some time. But overall, my overall message to you is I agree with you. This is a sector that needs tight regulation. This is a sector where there's a huge amount of consumer detriment. This is a sector where laws are being breached, consumer laws. And this is a sector where your voice needs to be heard. And I will do all I can to make sure that it is. Hope you have a good evening, and I'll see you again soon.